Sunshine State. This is Tampa Bay's 10 Talk.
It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. This is FLA Law on the radio. It is Tuesday at 5 o'clock. I know some people think it may still be Monday, but no, it is Tuesday. Happy Labor Day weekend. Hope you all had a safe and enjoyable weekend. But I am Matthew Noyes. I'm one of the partners at the law firm of Perenich, Caulfield, Avril Noyes, and we proudly provide this show to you, our listeners. We are a live legal call-in show. Our firm is a personal injury firm. We are the oldest personal injury law firm in Tampa Bay. We have been helping people after car accidents, work injuries, Social Security disability matters, and other personal injury matters since 1955. We are approaching 70 years of being involved in the community, and we're so proud and happy to have represented so many great people. This is the first Tuesday of the month, and so you do have a new host. That's me, Matthew Noyes. Jacqueline Bryant, my partner, had filled in for the last month. And so I am glad to be back for another month of FLA Law on the radio. And I'm not by myself, though. I have my co-host, Lori Robinson. Lori, thank you again for coming.
Always enjoy being here.
Lori doesn't get a month off. She pops in all the time, and we appreciate that. Lori Robinson is an attorney with our firm as well. She's a board-certified civil trial attorney. She and I work on all our cases together. Lori, can you introduce yourself and let the listeners refresh their memory about what a board-certified civil trial attorney really means?
Well, I've been with the firm. This is, I guess, the 26th year, hard to believe, and actually was able to attain that status in my early years here with the firm. And the significance of a board-certified civil trial attorney, the bar has different areas in which you can become specialized, and you have to have a certain level of experience and recommendations, you take a test and all of that. And then at that point, you are certified as a specialist in your area. My area, and our area, of course, is civil trial law. And there really are anyone who's a member of the bar can, of course, practice in areas that they choose to. And you can have a lot of experience without being board certified. But those of us that have taken that extra step to attain that recognition or credential, if you want to call it that, are a relatively small percentage of the attorneys.
Very small. It's like 2% of all the attorneys.
Something of that nature. And it is a way to basically establish your expertise in a particular area of law. And of course, as I said here, of course, we deal with personal injury, which would be the civil trial area. And I've always loved trial. That was my desire as a young person getting into law. Loved Perry Mason, loved debate in high school and college. So that's what I saw as a lawyer. And that's ultimately, so being certified as a trial specialist suits me very well in terms of what I think is so important in how you practice law in areas that could potentially end up in court. Now, as we know, very few these days end up in court,
right? But
you need to be prepared to do so if you want to get the best result.
And you need to start preparing for a trial, like on the first day that you meet with the client.
Absolutely, because what ends up happening, obviously, is as a case develops, you have a certain level of reputation, which our firm certainly does with the people on the opposing side. And in that situation, they know that we are fully prepared to try a case. In fact, we're looking at one we might have to try.
That's right, in about 6 weeks.
Right. So that is what puts you in the best posture to get the best resolution. Most people would prefer to get their cases settled. That's usually the best practice, but you want to get a settlement that reflects the value of your case. You want the best result you can possibly get, and that does require the willingness to basically let the rubber hit the road, so to speak, and go to trial if that's what has to happen.
Be the advocate.
Yes.
And that's Lori Robinson. I'm Matt Noyes. This is, as I said, a live legal call-in talk show. So if you have a legal question, you got about an hour to give us a call and ask us that question. The number is 727-441-3000. And that will get you into right into the show. And we'll be happy to tackle any questions that you have. As I said, we're a personal injury law firm, so we can tackle questions that have to do with personal injuries, such as car accidents, trip and falls, work injuries. We also do Social Security disability, so we'll be able to tackle those questions as well. And Lori and I have been practicing for decades, and so I think we can tackle just about any legal questions that you may have.
We'll take a stab at most
That's
things.
right.
Yeah.
So give us a call while we still have lines open. It is 727-441-3000. And if you have a question, but you don't really want to hear your voice on the radio, we are also live on our Facebook page. The page is Perenich, Caulfield, Avril Noyes Injury Lawyers. And we are live. You can see us in the radio station. And you can type in your question as well, and we'll be happy to tackle any Facebook questions that you have as well. So you got two ways to contact us, either 727-441-3000 or through the Facebook page at Perenich, Caulfield, Avril, and Noyes Injury Lawyers. So we're here till 6 o'clock, so we'll be happy to answer any questions that you have. But Lori, what I thought we would do, I had some time because Jacqueline was so kind to host the shows, that I looked at all the questions. So we take a lot of questions.
Sure.
We get a lot of callers throughout the week about all types of questions.
Mm-hmm.
So while we're waiting for a live caller, I thought what I'd do is, ask some of the questions that we hear from callers for potential clients and other clients that turn into. I'm going to have to change the names a little bit just because we have to protect the attorney-client privilege. But I thought it'd be good for the listeners to kind of hear what the questions are.
And chances are they're going to be questions similar to what many of the listeners have in their own mind.
Exactly.
Because it's covering a lot of ground.
Yeah. And one of the questions, and so I'm going to really focus on three areas of law that we do. It's going to be car accidents, work comp injuries, and also Social Security disability. Mm-hmm. So the first one that I saw, it was Logan from Tampa. He said, "What kind of damages can I be compensated for if I get hurt in a car accident?" I thought that was a very good question because people have all these different kind of ideas about what damages are they're entitled to.
And what they would think is fair. And so, obviously the damages, they have to be legally connected with the injury and pretty much flow from that. The obvious things, your medical bills, and lost wages. If you've lost income because your doctor has kept you out of work or you have restrictions that relate to the injury that you sustained, those would be the key ones. And then if you have, it gets a little tricky in an auto accident, you have to have a doctor who will confirm that you have a permanent injury. In other types of accidents, this isn't necessarily the case, but for that element, which really is almost the worst part of it of all, the pain and suffering.
Exactly.
That is
the impact it has on your life.
Right. And I think it's so challenging for people because so often they will have many different ideas about what the damages should be. But the worst part of the whole thing is just it's an intangible thing.
Right.
That is hard to put a number on. But it's a very real component of what's happened. And
I think what people seem to forget or aren't really that knowledgeable about is that in order to have pain and suffering after damages after a car accident, you have to have a permanent injury. You can have pain and suffering, and you would think that you'd be entitled to be compensated for that pain and suffering. But if you don't have a doctor who says that you have a permanent injury, then even though you had that pain and suffering, the insurance company doesn't have to compensate you for that.
Yeah, it is. It's one of those things where, the idea behind the so-called no-fault law, that we'd have a very simple system that is efficient, that you can get your bills paid up to a certain amount under that PIP coverage. And if you recover so that you have no problems, which, in the scheme of things, obviously, you'd like to have that. That's what you'd like. But it does seem a little unfair if that you can go through quite a lot of pain and suffering. And if you have fully recovered, you're not going to be able to actually recover that intangible element.
Right.
But that's only really in the automobile accident context because of that special law, that insurance law, basically.
Right.
other areas, like I was looking at a case actually just this afternoon that we'll be going to a settlement conference, and this individual was injured while riding a bicycle. There was a defect in the sidewalk, and as a result, the person fell and hurt themselves. Actually, that individual did, over a period of time, thank goodness, feel that they had recovered fully. Some scarring and some things like that, which that would be permanent. But we don't have to show a permanent injury in that setting.
Right.
The law doesn't require that. So a reasonable amount can be awarded for what the person actually experienced. Now, obviously, if you've had a permanent injury, something that doesn't go away, the value of the intangible damages would be a larger one because you're dealing with it all your life, basically. But yeah.
And when we talk about permanent injuries, people may think, and a lot of the potential callers, and think that, gosh, that means I have to be missing a finger, or I have to have a plate or screws in my bones. But that's not the case. To have a permanent injury, a soft tissue injury, and people minimize the term soft tissue, but if you have an injury to your heart, which is soft tissue, that's pretty significant.
Oh, yeah.
Your brain's soft tissue too. You have an injury to that, that's pretty
And so actually
significant.
the interesting thing, isn't it, we so often will hear, so say in the example you were giving before, what if you end up recovering? So say you broke your arm, you may recover fully. Hopefully you do.
Right.
And if that's, and yet that situation, even though it would seem more serious on the surface, it really wasn't, because you were able to recover from it. But in the traditional automobile accident setting, where people have often heard of the whiplash injury, if you actually have that occur and it doesn't go away, and that does unfortunately happen to a fairly significant percentage of people that are in automobile accidents, thank goodness, not everybody obviously, but that's a horrible injury because you live with it your entire life. And so that's a residual permanent chronic pain that you deal with. Now, it is a medical opinion. So a doctor has to basically say, unfortunately, I think you're pretty much as good as you're going to get. They use that medical term, maximum medical improvement, and you're just going to have to adjust your life to the new limitations, which often, of course, for people is that they say they love to play golf. Now they're not going to be able to play golf, at least without a lot of physical consequences, exacerbations, that sort of thing. But that would be a permanent injury flowing out of an accident if the doctor that you're seeing determines that it's not going to go away, unfortunately.
Yeah, and unfortunately, a whiplash type of injury, what happens is, and I'm not a doctor, but what happens is that the tendons and the muscles get stretched.
Yes.
Farther than they should be stretched. And the body has a tendency to heal that stretching through scar tissue. And so that scar tissue ends up giving you pain or restricted range of motion, which is permanent in nature, that you'll never get that blood flowing again to that area that was injured. And
it depends on the mechanics of the accident and the individual. So you may be a person, if you're a little bit older, unfortunately, you're going to be more susceptible to having an ongoing injury as a result of some trauma. If you're younger, hopefully you can walk away from it and not have an issue. But all of those things are a part of the damages that you would properly be compensated for. And then kind of going back to what we said at the beginning, it's all measured against actually that jury trial. Most cases won't have to go to that length, but that's how they're going to be evaluated. Is if the case did go all the way to a jury trial, what would a group of 6 fellow citizens evaluate as the extent of your damages?
Right. I used to use the analogy. Now, few people go to the actual malls anymore.
Yes, I know.
But I used to use the analogy that those people used to always come up to you and ask you if you wanted to do a survey.
Oh, yes.
It was the thing was, okay, what if you had those people who didn't really want to be there, have to be there, and present your case to them and have them do the evaluation of the case. That's really what the jury system is. People don't. Any person who wants to prove a case, prove a point, and be a jury member is scary on both sides.
Right.
You want someone who understands the importance of being on the jury and takes that responsibility,
Seriously, for sure. But yes, it is a little bit of a red flag if the person has a strong desire to take their time to do that.
Yeah, and you raised a good point, and actually Emma from Largo asked the same question. What are the chances that my case will require a lawsuit? And then we added, what are my chances that the case will have to go to a jury trial? Unfortunately, how does it have to go into a lawsuit?
Well, of course, what happens if you're after an initial injury, the person has to go through a process of treatment to find out what their ultimate situation will be. And once that's fairly clear, then what would occur is there would be a settlement demand made on their behalf in consultation with them to the insurance company to try to get the case resolved without having to file a lawsuit. And quite a number of cases, and I'm going to let you guess on the percentage, because I end up doing mostly the litigation. But I know we have seen many more cases have to go into litigation over the years.
Right.
But still, I would say, would you say it's most cases?
I would say it's about 50-50, quite honestly. I mean,
a pretty high percentage and a pretty reasonable chance that your case could be resolved without having to go into a lawsuit. But as insurance companies have gotten tougher to deal with over the years, it has become more possible that you would end up having to file a lawsuit. Now, of course, nobody has to file a lawsuit if they don't want to.
Correct.
But there are instances, and quite a few of them really, that in order to get an outcome that is reasonably commensurate with what happened, nothing ever makes it seem worthwhile.
But never fair, never just. That's for sure.
But in order to be treated somewhat fairly, it is often necessary to show that you are willing to go forward with a lawsuit. And I think insurance companies know which firms will in fact take it to a lawsuit. And I think that helps in getting the case resolved without having to file the lawsuit. Yes, I believe that it does.
I always say that our clients usually don't want to go into litigation. It's not because they want to go into litigation. It's because the insurance company fails to properly evaluate the case. I mean,
if you get a situation where your damages, let's just say that you've had medical expenses of, I'm going to say $15,000, something like pretty serious, could be worse. And the insurance company says, $5,000, that's what we're offering you, or $10,000, or even $15,000. It's something completely unrealistic, unreasonable. We're going to say, look, I think it makes sense. I think we can do a whole lot better for you. And I think it makes sense to file a lawsuit. And in that situation, most people are going to say, yeah, I guess I have to.
I have to. Yeah.
Right? But it's not that you wanted to. It's just the situation that was presented requires it.
So about 50% of our cases, at least, go into litigation. Of that percent, of those cases that go into litigation, about percentage-wise, how many actually go to a jury trial?
And I'm going to say that's your 2 to 5% kind of thing. Very small number. It depends on the case mix, certainly, but most cases can be resolved because in most situations, it's advisable for the plaintiff, the person that's been injured, but the defense also ultimately, in response, we're certainly going to say to a strong presentation that we're going to make, is going to recognize that it makes more sense for them to come to some sort of a resolution too. So usually, fortunately, it is possible to reach a settlement at some point. Now, depending on the case, it may take longer in some instances versus others. Sometimes you have to be literally right at the courthouse steps, kind of the case we're working on now. We're kind of not there yet, but it's next month kind of thing. So some cases are in that situation. Many cases will settle with a mediation that may occur 6 to 8 months after the lawsuit's filed. Many others will settle somewhere in between then and the courthouse steps. And a small number will ultimately go to trial. And, fortunately, we certainly aren't always successful, but usually we are successful and certainly in getting a result that is better than what was being offered. That's the reason you would go forward.
Yeah, no, I agree. I mean, a lot of our clients don't want to have to spend a week at trial.
Right.
It's not like at TV where it's done in an hour.
No.
It's usually 3 or 4 or 5 days, on a simple auto case.
A big investment, obviously we spend a lot of time, but this is what we do. But for the client, it's definitely nerve-wracking to be in that kind of a setting. We spend a lot of time preparing with the client. There's never a lack of preparation for the person to feel more comfortable, but it's still not something that most people would prefer to do.
No,
really.
I had a mediation this morning, and the wife of the person that was injured told me, listen, I couldn't sleep at all. I was up at 3:00. I was worried about the mediation. And so it's very stressful.
Yes.
We do it. We eat, sleep, and drink litigation, but they don't.
No, most people are not comfortable with anything that would be a legal proceeding.
And they also have a feeling that it's just not fair because they're under the microscope.
Right.
They got hurt because somebody else was negligent, but they're under the microscope.
Yes.
And they feel a sense of injustice in that regard as well, which I can appreciate.
Very understandable.
Yeah. Now, we initially talked about the damages that you're entitled to after a car accident, and we talked about pain and suffering. The damages that you're entitled to after a car accident, and we talked about pain and suffering, which leads us probably pretty smoothly into a workers' comp question. And that was, I think it was, James from Largo asked, what benefits can I receive if I'm injured at work under workers' comp?
Well, one benefit you don't get is anything for pain and suffering.
That's exactly true.
No, really, unfortunately. And I think that is one of the, I don't think we ever have a discussion with a client who has a workers' comp claim that doesn't include that. And it's and many times because the person injured understandably just cannot get that. It doesn't make sense. But you do with workers' comp, it does make you do have the opportunity to receive medical treatment. Now it is on the terms of the workers' comp insurance carrier. Their doctors, basically that are authorized by them. Yeah. But you do have that opportunity to get medical care. And in fact, you must, if it's a workers' comp injury, you're going to have to go the workers' comp route because your health insurance, the minute you explain what happened, is going to say, well, wait a minute.
Turn you away.
Right. Which is kind of a little bit of a funky area of how things work. But you will be entitled to, if you're off work due to your injury, you'll be entitled to some wage payments.
Right. You get wages and medical from doctors that the workers' comp gets to choose.
Right.
And that's really it in terms of workers' comp. But if you have questions regarding auto accidents, workers' comp, Social Security, disability, it's time to give us a call, 727-441-3000, just like the caller we have on air now. Hey, Coach, this is Matt and Lori. Coach, are you there?
Okay. Yes, thank you. Yes, I am. Thank you very much.
Hi, Coach.
So first of all, I want to say congratulations on 70 years. Well, almost 70. That's pretty impressive.
Yeah, thank you.
And then my next question is, it's pretty simple. So, I'm an honorably discharged vet. Does that transfer to Social Security disability? Is there a process for that? What does that look like?
That's a very good question. That's a question that we have a lot. We have a lot of vets, and thank you for your service. We do appreciate you and all your service personnel that did help out.
I love our country. Let's do it again.
We do too. That's for sure. But we have that question a lot,
yes.
and Lori is right here, and she can address. What does being disabled as a veteran, how does that play a role in securing Social Security disability?
Right. So they do. There is what they've done. It used to be that the Social Security system actually would give some deference to the findings of the Veterans Administration and supported disability, but quite some few years ago now that changed, and it's because they're very different systems. So the Veterans Administration system for assessing disability is very different than Social Security, but there is still an acknowledgement of veteran service. And if you are 100% disabled under the Veterans Administration, they will actually expedite your claim, which in Social Security, that can be kind of significant, even though they certainly are. I'm going to say they're a little faster than they were when I started doing this so many years ago, but it's still a long bureaucratic process. So that's somewhat of a help. Now, having said that, although they will not defer to the VA finding, all of what's there obviously is supportive of a claim for disability. And I have never been in front of a Social Security judge that didn't lean over, I don't know necessarily backwards, but really that was very favorably disposed towards veterans who have served their country.
Right. They'll use the VA records to support the Social Security disability claim for sure.
Yeah. Now, it is a little bit challenging, though, because the veterans' records tend to be, they're computerized, and so they aren't necessarily as detailed as Social Security is interested in. So it's the kind of thing that requires a little bit of counsel. But if a person, you or anyone you know, is disabled under the veteran system to some percentage, it definitely is something that will be considered. But it doesn't. Actually, it's not conclusive within the Social Security system, because Social Security looks at whether or not the person is able to function at what they call the substantial gainful level, which this year is $1,550 gross a month. So it's very, very much a full total disability system.
But can they receive both VA benefits and Social Security disability?
You can receive both benefits, and a person that is disabled under the VA system and really is not able to work at that level I was just describing absolutely should look into it. I mean, we have many, many veterans that receive both benefits, because obviously, if you're disabled under the veteran system, there are some issues that should be considered by Social Security.
Sure. Coach, did that help?
That's very helpful. I guess my only follow-up would be this. So when you say it's kind of a long and bureaucratic system, can you give me,
Oh, yes.
a rough estimate of time frame?
Sure.
Okay.
Yeah. While if a person's 100%, then they will expedite the claim. But even that is an expedited setting of hearing. And I've seen those claims get set within approximately a year. But the normal Social Security process is initial application. They take months and months and months, 8, 10, a year to review the application, and typically will deny.
Right, typically will deny it.
Application. That's normally what happens for well over 60% of the applicants. And then the next process is a reconsideration, and that is pretty much the same type of review, different set of eyes, but the same type of eyes. Typically, now you got another several months, and over the last, I'd say since COVID, they've been very slow on the processing part. I'm personally assuming it's staffing issues, whatever it is, but that may also be 6-8 months. So you can be 2 years in that initial application process. Once you're been denied twice, then the next step is to request a hearing before an administrative law judge. They do those on Microsoft Teams now, video. We do them from our office. That is pretty efficient. Now, from the time you request the hearing will probably be set 6-8 months, maybe 10, but pretty efficiently for that part of it. So you can be looking at anywhere from 18 months to 2 years, and that's probably a pretty general experience. Could be a little longer for some, could be a little shorter for others. There are situations where they will approve on the record, and obviously we try to make that happen where we can, but that would have to be a very clear medical record, or a situation that requires a compassionate allowance, something of that nature. So people that are thinking about Social Security need to be prepared that it is a process that takes quite a while, unfortunately. I mean, that's just the nature of the bureaucracy, and I guess the number of claims they process probably.
And the sooner you get into the system, the better it is,
yes,
because it's going to take that 18 to 24 months.
And also, Social Security, we always recommend people more or less getting in the queue, because it does take a long time. But Social Security looks at 12 consecutive months of being unable to work. So you may have, very often we'll have people, I'm going to give the example of a stroke. Terrible, devastating, yeah, but not clear what the ultimate outcome will be within a period of 1 year. And, fortunately, some people very often can make a pretty good recovery from a stroke, but they may not. So you really are going to ultimately have to be able to show being unable to perform any substantial gainful activity for 12 consecutive months, and then the normal situation is that is expected to continue. So even though it takes a long time, in a certain way, it kind of works to the benefit so that medical record is clear if it hasn't been clear. Yeah, so even though I like that they expedite these veterans claims with 100% disability finding, it's not always to your benefit if the record needs to be developed a little more, which sometimes with the VA health system, it's not the system is a problem, but it's just the level of detail that goes into the records. I mean, they're voluminous, but a lot of times they don't give details on the actual limitations, the functional limitations that prevent work, and that's key. That's what Social Security is looking at. So many times if a person has an option to supplement their care with a private orthopedic visit, if it's an orthopedic problem or whatever it is, that can help a lot because you're trying to establish what your limitations are so that Social Security has the benefit of that. Yeah. But unfortunately, I wish, I don't think there's one client we have that we don't have to basically explain what we're sharing with you. It's a long process.
I mean, it's a fight that's worth fighting because you and others have fought hard or have worked in order to be entitled to the benefits that you've paid into.
It's just you paid into the system and you're asking for your retirement early due to a medical condition that prevents working. So it absolutely is a benefit that should be pursued, when that's the situation. But unfortunately, you have to be prepared that it's going to be a process. Now, we do everything we can on the front end. We have excellent staff that will be all over the people that are examining the claim, but the end of the day, the level of review that occurs in those initial applications are something that it's not very easy other than shining a light and making sure they have what they should look at. It's not very easy to alter that part of the process. It's once you get to a hearing, then in front of a judge, we would, if we take the case, we'd expect to be able to be successful.
So I hope that was helpful to you, Coach. We appreciate you listening, and we do appreciate you calling in.
Very helpful. Thank you very much.
All right.
Last question.
Sure.
Yes or no. So is disability an all or nothing thing, or is it percentaged out like in the VA?
Say that again.
Very, very good question because we hear that a lot. Is Social Security disability a percentage thing?
No, right. That there's no partial disability. It's a total disability standard. So that's why the rules changed about giving deference to the disability assessments in the military because it's a complicated system of formulas that it rates different things.
Yes, it is.
Yeah, right.
There's a VA math. There's regular human math.
Yeah, right.
And they ain't the same math.
No, right. And so there's nothing like that in Social Security. They're looking at just the person's functional limitations. Are you limited in how long you can sit, stand, what you can lift or carry? Or you have problems with concentration, good days, bad days that mean you're not going to be able to observe a customary attendance schedule. I mean, they're the functional limitations, so problems with your hands or whatever, whatever it would be. So, and so with the VA, they break it out with that complicated percentage system, but that's not Social Security. And so it's really, and there can be many situations, friends that, have various ratings on different things, but, for Social Security, in effect, you're talking about something that's completely disabling. I mean, if you're able to do any significant amount of work that would earn more than that small amount of $1,500 gross in a month, then you don't meet the essentially total disability standard.
And that's what I was going to ask you, Lori. Yeah. I mean, how does Social Security define disabled?
Right. So they're looking at that the person is unable to participate in what they call substantial gainful activity. And that means work that's pretty much part full-time, not necessarily all 8 hours, but pretty close to that 5 days a week. And the person earns $1,550 gross per month or more, actually $1 more currently. That amount goes up every year, $70 or $100, but this year it's $1,550 gross in a month. So it really is intended to address total disability, even though a person could work part-time, but very, very part-time. It would have to be under those limits. They'd have to be limited to that.
Right.
Now,
So to be disabled under Social Security regulations, you would have to have a condition that prevents you from working more than a year, earning substantial gainful activity, and there is no job available within the work surroundings that fits into your restrictions and limitations.
And that is something, a lot of times people will, of course, focus on the type of work they have done. Social Security will look back 5 years now, it used to be 15, and they'll look at what type of work you've done as you performed it or as it's generally performed in the economy. But depending on your age, so if you're a young person, and they define young as 50 or under, or under 50 rather.
I'm offended.
If you're a younger person, then they're really looking at basically the simplest job you can imagine. Okay, just anything really. As you get older, over 50, then the rules become. They have their own little chart too. So, but then they'll take into account somewhat that it's a little more difficult to adjust to. It's a completely different type of work, as you get a little bit older. But lots of questions, really, and we're always happy. I'm so glad you called, and we're, if you have other questions, you feel free to call the office even, because it's actually very complicated, and
it's very case specific as well. So, Coach, we really do appreciate you listening.
Totally understand. And you guys have been very thorough, and I really appreciate it.
Great.
And once again, congratulations on your longevity and experience. That's impressive.
Thank you very much. And again, thank you for your service. We appreciate that.
All right, thank you.
Lori Robinson or Matt Noyes, we are here for another about 18 minutes, 17 minutes, here to answer any questions that you have. Coach had very good questions about Social Security disability, and it kind of leads me to the one question that most people ask, and that is, what's the difference between Social Security disability, SSDI, and Social Security income, SSI?
Right.
People get those confused all the time.
Yes, and I actually was talking with a lady earlier today, and because it's not clear to people. So there are two programs. The Social Security disability is based on what you have paid into the Social Security retirement system. So when they take those Social Security taxes out, that's what that's for. And it is intended, as I said before to the other gentleman, you're really getting your Social Security retirement early because of a medical condition that you could not, as a result, you're unable to work. And so in that scenario, you're getting what you have paid into the system, and they have a formula to calculate your benefit. If you have not worked that much, and there are really two ways that can happen. So you maybe didn't work that much to begin with, or what can happen, and this was the situation for this lady I was talking with. If you worked pretty good for quite a long time, and then something happened, and you stopped working, or stopped working on the books, which can happen, and you're not paying into the Social Security system, if 5 years go by in the usual situation, that you haven't been paying into the system, then your work credits are no longer current enough under their rules to qualify for disability. Now, you still have your Social Security retirement for when you hit the full retirement age or whatever. But so they have these rules that you have to have been working fairly recently before you apply for disability. But
you'll hear that you don't have enough quarters to qualify for SSD. And that's really what that means. Yeah,
and because each year, you can earn a maximum of 4 quarters each year. It doesn't take very much. It's probably $6,000 a year, and you earn your maximum of 4 credits. But if you haven't been working for a while, they do have a rule that says you're not going to be able to apply for the disability. Now, disability, you could be a billionaire, and if you're disabled, it's your Social Security benefit. SSI is a welfare program. So if you don't qualify for disability, because you don't have enough work credits for whatever the reason is, whether they're not recent enough or you just haven't worked enough, now it's going to be based on your financial resources, and it's very limited. You can't $2,000 in the bank is all you could have, one car, and it's just quite limited. So that's a situation, and that benefit is, I say it's a welfare benefit. It's $941 a month right now, and a qualification for Medicaid if you do qualify for it.
You still have to have the same condition.
Yeah, it's the
whether
same exact medical standards.
medical or even a mental condition that prevents you from being able to do substantial gainful activity.
Yeah, so they're the exact same thing in terms of the medical requirements and how they'll evaluate this. But if your work credits aren't sufficient, then in that situation, you could easily be making too much money, even if you weren't making very much, to qualify for SSI. So I don't even know after a person's heard this if it's like, huh? What, I don't know what you're talking about.
And that's what I was going to say. If you have questions not between 5 and 6 o'clock on Tuesday, and you want to call our office to have those questions answered, I mean, we're here. We're here to guide you through the maze of Social Security, workers' comp, and auto accidents and other personal injury matters.
And how many times, a lot of times, we'll get a call from someone who is still working full time, but they know that they're not going to be able to keep that up, at some point in the foreseeable future. So I would say I spend a fair amount of time talking with people, and we're happy to do this, to just counsel them and give them some general information to kind of plan, what their future will look like and kind of prepare themselves, like we talked with the other gentleman, that it's a long process, but also to look at, what are the requirements, because people don't really know.
And I think that's why our firm's been around for so long, is because we would go that extra step. We do spend a lot of time talking to people, even on cases that we cannot
Ultimately
take or won't be able to help them with. But they still have questions, and they still deserve answers. And
and you can see, like, I love that the gentleman was complimenting the firm on being in business, the practice of law, for so many years, because it is actually unusual for a law firm to have that level of stability. And I would say, and longevity, I would say that's in large part due to the fact that we do care about the community, and we see ourselves as professionals, and with a area of knowledge that we can help people. So,
I always say we meet a lot of good people after bad things happen to them, unfortunately.
Yeah.
And one of the bad things that happen is getting hurt at work. And many times people think that they're entitled to a settlement if they get hurt at work. We know that after an auto accident, if you get hurt, you can bring a claim and have a settlement for all your damages. But workers' comp's a little bit different. There are settlements in workers' comp. But can you explain to our audience really what a workers' comp settlement is and how it's so much different than an auto accident settlement?
Because again, remember you asked earlier, what is the difference between an auto accident or something like that and workers' comp? No compensation for pain and suffering whatsoever. So in workers' comp, the insurance companies do often have a desire to close out their file, but they have in mind closing it out at a discount for themselves.
Sure.
And how they evaluate the file the claim is based on what they would have to pay. And what they would have to pay would be the reasonable medical care under the workers' compensation standards, which they pay a fraction of what even regular health insurance pays. And they would evaluate, depending on the nature of the injury, what are they likely to have to pay over the course of the injured worker's lifetime? Because so long as there is a need for medical care that the workers' comp injury was the major contributing cause of, more than 51% of the reason, then they're going to be on the hook. But
as long as the injured worker sees a workers' comp doctor at least once a year.
Yes, I was talking with a friend of mine last night, actually, who had an injury in Colorado, but it was quite a while ago, and it's been quite a number of years since he has actually seen a doctor. And I was telling him, and he was going to check into it. And I don't know what the law is in Colorado, but in Florida, if you're not, and we have probably a little bit more restrictive law in workers' comp than some places. So, hopefully it wouldn't be that way for him, but it could be. Here, you need to be seeing a doctor or receiving a benefit, which basically means seeing the doctor at least once a year.
Right.
Yeah.
And then you could make a settlement claim. And really what it is what are you going to cost them into the future? Mm-hmm. And what discount can they get in order to close their case? Insurance companies are in the business of risk management. And if they can close a case, they'll want to close the case. Mm-hmm. And so usually the battle is what's the future medical care is going to be. There may be a situation where there is permanent total disability benefits. Mm-hmm. That is, if someone cannot return to even sedentary work because of a work injury, they'd be entitled to the permanent total disability benefits, which is 66 2/3 of their average weekly wage. It used to be for the rest of their life. It's not for the rest of their life anymore. I think it's up to age 70 now, maybe 75, but I think it's 70.
And it's a tough standard in workers' comp.
It's almost impossible.
Right. They used to also defer to the Social Security standard, and of course that changed some years ago. So it's now very, very challenging. But we do have cases, obviously, that that's appropriate, and we argue for. So it's not like it can't be considered. But
so you can do a lump sum settlement of your workers' comp case, but it's for future medicals. In essence. Mm-hmm. And oftentimes they make you resign from your job if you agree to settling your case for a lump sum amount. The basis that they give, the reasons why they give that is really twofold. One I believe and one I really don't believe that much. One is they don't want to pay for a back injury on Tuesday. You go to work on Wednesday and hurt your back, and then they have to pay for it all over again. That one I can kind of understand. Mm-hmm. The second argument that they have is that they don't want you to go back to work and tell them that you had a settlement of your work comp injuries because there's going to be a flare-up of work comp claims. I think that's kind of bogus because a work comp claimant, you have to prove your worker's comp claim. Right,
and I think, you could agree to confidentiality and things of that nature. I think and it's the insurance company. Occasionally we'll see a situation where we can get an exception from that rule because if you don't want to leave your work, then you really don't have an option on that.
Right.
Yeah.
But Lori, what happens if both sides can't agree to a settlement amount? In an auto accident, if we can't agree to amount, a jury or a judge, but a jury most of the time gets to decide the amount. How about in a workers' comp case?
Not in workers' comp. There's nothing that we can do to force the workers' comp insurance carrier to make any kind of a settlement offer to settle the claim and close it out. So all that you have in workers' comp is if you can't reach an agreement, then you have your right to see a workers' comp doctor when you need to, assuming you go once a year, and you have that protection. And we have clients that have been on workers' comp for years and years and years.
My daughter is 34 years old, and I have a claim that's older than she is. So, so it's actually she's 36 years old. I take that back,
goodness,
but she's still older than she is.
Yeah.
I'm sorry, Crystal, for giving your age away. But workers' comp also, the process is a little confusing and a little difficult to understand as well because it's not in the judicial system.
Right.
It's in the administrative system, kind of like Social Security is, but you have an administrative law judge deciding the case. But can you explain, we have a few minutes left, can you explain the process? What happens if workers' comp denies, let's say they deny the whole case? What does the injured worker have to do in order to present their case?
Right. So it's you're totally restricted by the specific laws that apply to workers' compensation claims. So you can file with a lawyer. Certainly couldn't do this on your own. In theory, but you wouldn't. So you would file a petition for benefits in a case like that, where we would challenge that. We would say it is a compensable accident, and then you have the little bit of the challenge that they only have to consider workers' comp authorized care from doctors they've authorized. So in that scenario, they haven't authorized anybody. Now, there are various ways you can work around that, but it's an administrative system that has a lot of restrictions that make it difficult in those situations. But you go to, there's a court, and it's an administrative court, and
And before you go to court, I mean, just like in the auto case, there's depositions.
Right.
There's requests to produce. There's no interrogatories like in there, but it's a whole investigation.
Yeah, there's certainly, I mean, you can find out, if there's a dispute about how the accident happened, which, then we can take depositions of any of the witnesses or the employer. Obviously, if you are treating, as you must, your medical records would be helpful from a factual perspective in establishing your injury, but we would still have to obtain an independent medical exam through various mechanisms that are available, so that there would be medical opinion that the judge could consider.
Right.
And then we would ultimately, if it can't be resolved, really, honestly, most of those are resolved without having to go to a hearing, but it's not uncommon to have to roll right up to it occasionally.
Right.
But if not, then you have a hearing in front of the judge, and the judge will then, issue an opinion.
So there's a long process. It's filing the petition for benefits, and then it's the whole discovery phase.
Now it's not like Social Security, because they do have timelines in workers' comp, and so, it's 6 or 8 months or something like that. But
and you have a mediation too. It's state ordered mediation as well to go there. The difference in workers' comp is, though, if you file a petition for benefits and we prevail, then the insurance company has to pay the attorney's fees.
Yes.
Not like in an auto case, they don't pay attorney's fees in most situations. But in the workers' comp case, if you have to fight the battle and you go to court and you win the battle, then the insurance company has to pay the fees.
Fees on an hourly basis. Yes, and that is helpful.
I think it's because
that's been a battle. Obviously, the legislature taking away and the courts returning, and now we're just because it's very difficult on some of these issues. It would be hard to get a lawyer to help you.
Exactly. You're fighting, for a doctor, and some wages. It's very hard to find an attorney that can really handle the case. And that was litigated. That went all the way up to the Florida Supreme Court too, because the statute tried to limit the attorney's fees in such a way that made it impossible for injured workers to have proper representation. One thing I think is important, I forget who asked that, but here it is. It was Mason at Belcher. He said, "How long do I have to report my injury?"
Well, you have 30 days, and that is something you should always report the injury as soon as possible.
And when they say report the injury, you have to report it to the workers' comp carrier?
Well, to your employer.
To your employer is all you have to do.
And it's the kind of thing we'll see fairly often. People will hope they're not going to have a problem, and then there may be a delay, but you really need to let your employer know as soon as something's happened.
Right. And I always say document it, put it in a text message, put it in an email, let them know you got hurt. Because we'll hear the carrier say, well, I didn't have notice. It's not the injured worker's responsibility to notify the carrier. It's the employer's responsibility to notify the carrier. He just needs to make sure that he notifies the employer. Well, we're almost wrapping up. We do have just about a minute left. Lori, thank you. If Coach or any of the other listeners had a question for us, not on Tuesday during FLA Law, how can they reach us?
Well, please call us at our firm, 727-796-8282. You can also search us out on the web, usalaw.com.
And also voiceoftheinjured.com as well. And we're here. We're here to help you, not just on Tuesday, but every day.
Yes.
So please feel free to call us. I'll be back next week, and I'll have Bill DeMas on as my guest, and he'll be talking about short-term disability and long-term disability. We appreciate you taking the time today. I always wish you to drive safely and watch out for those who don't. Have a good night.